Great. Okay, we're showtime.
All right. And everyone's super punctual. Love that. So first and foremost, just want to welcome everyone and thank you for taking your time out of your day to join us. For those of you who are new to our monthly webinars, my name is Erica Lockhart.
And I'm Lorin Muttenberg.
And together we are Ahead of the Curve Homes with Compass. And today we're actually really excited because we are joined by real estate and estate planning attorney, Robin Chow. Robin received her JD degree from the University of Southern California and has been practicing law in the state of California for 32 years. She spent the first 7 years of her career as a corporate litigator and has spent the last 25 years managing her own private practice where she specializes in probate, estate planning, and real estate law. So Robin, thank you so much for taking the time out of your busy schedule to be with us today and field lots of questions relating to estate planning and probates and all of that fun stuff. So before we start and get into the questions, Lorin and I will just kind of provide you with an update on the market, and then we'll get into the specific questions for Robin.
Okay, great. And I'm about to share the screen, but just quickly before I do, we have prepared several questions for Robin that we hope will cover everything that you're thinking about. But if you have more questions during our discussion, if you take your cursor down to the bottom of the screen, you'll see a little bar come up with a box that says chat. So you can click on the chat box and just type your question in. And we will make sure that we get to your questions, before we're through. And please, there's no such thing as a dumb question. Please ask whatever you're thinking. So let me share the screen just so we can go over the comps and this market stats. Okay, can you guys see that?
Yep.
Okay, great. So going through these. Here's what we're going to discuss today. We kind of introduced it already. So here are the market stats.
Okay, so first we're going to focus on the key areas and neighborhoods that we serve, Baldwin Hills, Baldwin Vista, Ladera, View Park, and Windsor Hills. So here we see that new listings are actually down by 17%. While pending sales showed improvement and are up year over year by 10%. Closed sales decreased by 32%, and the average sales price has held fairly strong with only a 4% decrease in price. So while new listings are still down in these markets, it's important to note that over the last couple of months, we've really seen an uptick in the real estate market and just overall activity in general. I think buyers are more comfortable viewing properties. Sellers are more comfortable now listing properties and having buyers come through their homes. And what we're really noticing is that historically low interest rates are really continuing to kind of drive and fuel the market right now. Okay, so moving on to the, I'm sorry?
Yeah, nothing, go ahead.
Moving on to the August condo market. So here, new listings, pendings, and closed sales are all up with very healthy increases. Average sales price increased by 16%, and average days on market actually decreased by 60%. So just another sign of the real estate market, rebound kind of post the stay-at-home order.
And we are somewhat responsible for this, I might add. Just a shameless plug, but we sold another village. We sold another Village Green unit at a record price, highest ever sale there. And that's part of what's driving these prices up. Okay, so Mar Vista. Mar Vista is really hot, really strong area. New listings, in August, new listings went up by 31%, 39%. Pending listings went up. The amount of listings sold in August actually went down, and the amount of time the property spent on the market went down by 50% as well. And the average sale price went up. So, Mar Vista continues to be one of the strongest areas in town. Not seeing any big change in prices. Okay, and then here's the condos and townhomes in Mar Vista. New listings are up by 50%. Pending listings are up by 59%, which is quite a lot. And sold listings are up by 27%. The days on market is down by 39. And the average sales price from August 19 to August 20 went down by about 6%, which is not a whole lot. And with more on the market, it makes sense that with more listings that the price would go down slightly.
Okay, so moving on to Culver City. So here we see volume is up across the board, with new listings increasing by 34% and total sales by 30%. Here, the average sales price, it decreased by 18%. And this can actually be attributed to two sales. There was a fixer and a distressed probate that sold well below market. So those two kind of below market sales are really kind of influencing the overall sales price decrease. Moving on to the condo market for Culver City. Okay, so same story here. Volume is up across the board, including the average sales price, which actually increased by 11% here. Overall, new listings were up by 35% and days on market decreased by 43%. Condos in Culver City right now are not sitting on the market for very long at all. They're a very hot commodity. On average, they're sitting on market for 4 days. So it's extremely hot condo market. Again, I think the stats are showing a very robust market. Many of the properties that we're actually writing offers on for our buyer clients are receiving multiple offers to the tune of like 10 to 25 offers. So while inventory is, definitely starting to pick back up, it's clear that there's still not enough inventory for all of the active buyers in the marketplace. So from a seller's perspective, it's actually a great time to sell and to list your home because you don't have a ton of competition and you have really, really high demand.
Yeah. And in Culver City condos, I mean, the prices in Culver City have climbed so high, over recent years that condos are the only quote unquote affordable thing in Culver City, and they just continue to churn. And now we go to Santa Monica. So Santa Monica, there's new properties are up by 38%. And there's more new listings in August of 2020 by 38%. There's more pending listings just by a little, by 5%. There's more sold listings in August of 2020 versus 19 by 20%. And the average days on market went down in 2020 versus 2019. Again, speaking to the robust market. And the average sales price looks like it's down by 21%. But that's a little bit skewed because in 2019, there was a $15 million sale in those sales in August that bumped up the average price. And in 2020, there was the highest sale was 7.8 million. So that's why you find Santa Monica is not down by 21%. It's just this month is because of that. And then condos, again, I mean, look how many new listings in August of 2020 in Santa Monica, 89 condos versus 54 the year before. 71 pending in August 2020 versus 54 the year before. So it's kind of similar to Culver City, like condos are the most affordable thing in Santa Monica and people are trying to get in. Sold listings barely went up, days on market went down, and the price, it shows that a 16% decline. You would expect a little bit of a decline with so much inventory, but again, the prices can be skewed by one high sale. So the condo market in Santa Monica is extremely active, similar to Culver City. Okay, so let me stop the screen share. Okay.
Okay, so now we are going to proceed with our Q&A section with Robin. So I think, Lorin, you have the first question.
Sure. Okay, Robin. So it's a really basic question. What is estate planning and why should homeowners do it?
Okay, estate planning, the way that I look at it, estate planning is a legal document, a plan that directs the management of your estate from the date you sign it, so even before death until long after you die. And homeowners should do it. One, it saves money. It keeps your estate out of probate, which is very expensive. I think we're going to talk about that at some point. And it is a good tool to manage your life. So there's several documents that are a part of an estate plan. It's a living trust. There are powers of attorney. There's a will. And so if something happens to you while you're alive, let's say you lose capacity, you get dementia, powers of attorney will appoint someone to be an agent to handle your affairs, handle if your property is not in a trust, that agent can handle property that's not in a trust, and that sometimes happens. Property that's in a living trust, there's a trustee who was nominated, a successor trustee, to take over if someone lacks capacity. So it's a fantastic tool to keep whoever establishes it, a single person or a married couple, to keep them out of court during their life, keep them out of conservatorship court, and keep their estate out of court after they die.
And so when you say it keeps, your property and keeps your estate, I guess, out of probate, can you explain what is a probate?
A probate is the administration of a decedent's estate by the court. So it's under court supervision. So everything that happens, it starts with a petition, and everything that happens typically will have to be approved by the court. Used to be about a year process. With COVID, it's become a nightmare. It's probably going to be 1.5 to 2 years for a simple probate. If something is litigated, you just double the time. So that's the essential definition of a probate.
Okay, so how do we avoid this? How do we avoid probate? Sounds like a nightmare.
You can avoid probate several ways. I kind of look at it as an estate plan, and I tell my clients when they come in, you can have a living trust, and the living trust needs to be funded. It can be funded with real property, which means the property is just conveyed to the trust. You can look at all of your assets. What we do is list all of your assets. We go over all of them. How are we going to pass them without probate? The ways that you can pass without probate is the easy one: a living trust, pay on death beneficiaries. There's another manner, transfer on death deeds, which I don't like that much, and we can talk about that if anybody's interested, but that's a deed where you convey the property to yourself with a remainder interest after you die to whomever your heirs are. And some people like that because they can't afford a living trust. The problem with that document is you've got to do it for every property. You have to revoke it every time you want to change the beneficiary, and there's some title issues with it too. But the best way, if you have real property, is a living trust. If you have no real property and it's just cash assets or accounts, pay on death beneficiaries. And you can do a combination of all of those things.
Mm-hmm. And what are the disadvantages of probates, if any at all, in your opinion?
Oh, yes, they're a huge disadvantage. Okay, so a living trust, probably a minimum is about $2,500. If you get an attorney to do it and it's done properly, do it on legal, one of those legal websites for much cheaper. But I fix those. I end up charging to fix those after the person dies. But probate, minimum. Let's say you have a $500,000 estate and one piece of property and it sells. That attorney's fees for a probate with a $500,000 estate and a sale, probably about $22,000 in attorney's fees. Court costs probably anywhere from $3,000 to $8,000. And then there's also executor fees, which are less than the attorney's fees, but they're substantial too. And that would be probably $18,000. So if you add that up, you can see how expensive a probate is. And then couple that with delays. It doesn't make sense ever. I love probate. I make much more money handling probates than I do with estate plans. But the smarter way to go is an estate plan, particularly for the beneficiaries.
And I just have another question. With the costs, are those costs typically the costs and fees, are they due upfront or after the asset is sold, or a combination of both?
It's a combination of both. So court costs are due upfront. The court has to be paid. Referees appointed by the court have to be paid. Legal publication, all that has to be paid. Every filing fee for a petition is $500, and you've got to do that at least 2 times, sometimes 4 to 5. Attorney's fees, don't let any attorney ever tell you they get their fees up front. They don't. Attorney's fees and executor fees are paid at the end of the probate, after the court hears a final account and petition for distribution, and the court has to approve the fees before they can be paid.
Okay.
So that part's not so bad, but it's still a waste. It still takes money out of what would be the beneficiary's pockets.
Right. Okay. That was what are the costs. So, and the figure that you gave, I'm just curious, the figure that you gave up on a $500,000 estate of $22,000 to go through a probate, is that including all of those fees, the attorney and the court, or is that just a portion of it?
No, that's just the attorney's fees. The
That's
executor
just the
fees
attorney.
would probably be another $18,000, and then the court costs, depending on the kind of bond, could be anywhere from $3,000 to the, and that's paid up front, could be anywhere from $3,000 to $5,000 or more, depending on what has to be done in the estate, whether there's litigation.
So, I mean, you could really be approaching like 10% of the estate.
Oh, sure.
Yeah. Okay. Okay. So then the next question is, Erica, this is supposed to be yours, number 6, but I'll ask it. What is a will?
A will is a legal document signed by the person who has the estate before the person dies that controls the distribution of the estate, dictates the distribution after the person dies. The name typically doesn't have to, but will name an executor to manage the estate, and then it'll specify the beneficiaries and what they get. And that document has to be admitted to probate.
Okay. And what are the benefits of having a will?
The benefits of having a will over what's called intestate succession. So intestate succession is dying without a will. A will merely gets admitted to probate, and it tells the court, it's a contract between the decedent and really the court. It tells the court that this is who is going to get my estate. You can disinherit, or you can give less to one child and more to another. If you don't have that will, then and you die intestate, then the probate code dictates who is going to get your estate. And sometimes it's very fair. It's similar to what a married couple would do or a single person would do. It might be if you die intestate, it could be, and you only have children, it would go to your children. But if you're in a blended family, intestate succession is really cruel to blended families. Let me give you an example. If you're a couple and 2 divorced people, and you've got your own children, and you marry, and let's say the wife has nothing when she married the husband, and he had a house from the first marriage, and then he transfers the house to her as joint tenants, and he dies first. She's now the owner of the house, and when she dies, if she dies intestate, the sole beneficiaries of a house that wasn't hers are her kids, and not the kids of the person, of the husband who actually owned the house and transferred an interest to her. I think the fair thing would be, it would be split between both sides. Mm-hmm. But intestate succession is a difficult one. So wills are important because wills, the person can dictate, and they, you hope they will be fair. They don't have to be, but the person can dictate who is going to get the estate rather than the probate code making the decision. But still has to be probated, and it's no cheaper than intestate succession, other than if a will waives bond, it saves that cost, but otherwise the costs are the same.
Got it.
And I think you may have already answered this in your explanation, and let me know if you have anything to add, but what is the process when there is a will?
Process when there is a will, the original will has to be lodged with the court. So anybody who's listening who has a will, make sure whoever your executor is knows where the original will is, or you keep it in a safe place, either in a safe or in a metal cabinet that locks and is safe from the elements because it has to be admitted. And if the original will is lost, then you can get it admitted, but it becomes a problem, and people can argue that maybe you destroyed it, maybe you didn't intend for this to be your will. So it's admitted to the court, it's lodged with the court, a petition is filed with the court by the executor to be appointed. There's an appointment hearing, barring no objections. At the appointment hearing, the executor is appointed, the will is admitted to probate, and what are called letters of testamentary are issued. And that's the legal document that allows the executor to handle the business of the estate until it closes.
Okay. Sounds complicated. What are the what are the top mistakes that people make when they're creating a will?
Top mistakes they made, I think they cheap out. They either do it themselves, and for a will to be admitted into probate, all of the formalities have to be complied with. And so they'll be missing signatures. The testator, who is the person who signs the will, sometimes doesn't sign, or they sign in the wrong place. So the formalities is one. The other is, and I think it's the same with trust actually, is who you pick to be your executor or your successor trustee is one of the most important decisions that I think a person can make. And what I get all the time is the parent wants to pick the oldest because the oldest will be offended. They don't pick the person who is, basically it's a CEO running a small estate for the time, from the date of death and sometimes sooner through the date of distribution and close. So you have to have someone who can manage money. You have to have someone who's trustworthy. You have to have somebody who's kind of up for the emotional battle, because it can be a battle at times. And sometimes people pick out of emotion because they don't want to hurt someone's feelings. And oftentimes it should be a third person who has nothing to do with who the beneficiary. Sometimes the beneficiaries, none of them are, should act as a personal representative. But it's a hard process, particularly for parents, to decide to pick someone other than, the oldest, or the one who went to law school, or the one who's a doctor. Sometimes the busiest person isn't the person to do it.
Right.
I'm not the successor trustee of my parents' trust, and I drafted it. They know it. I'm too busy. So
That says a lot.
Yeah. And I was all for it.
Okay.
And so what happens when there is no will? Like there's no will, there's obviously
Okay,
there's
no will. Intestate succession. So when there's no will, there's a similar petition is filed with the court to have what's called the administrator appointed. And the administrator is selected by the court by priority. So if you're a married person and you left a spouse and children, the spouse has priority to serve. So the spouse is the person who would likely serve. If you left no spouse and several children, all of the children have equal priority. Only one person should file. I always encourage people when they're siblings to talk that through, pick the person so you don't end up in a battle. Sometimes that doesn't happen, and you get two people filing, which are called competing petitions. And then you end up with a battle that prolongs probate. But ultimately, the court will pick, after trial, one person.
Okay. And so you've started to explain this. Certainly there's a difference, but what are the key differences between probate? But what are the key differences between a will and a trust?
Okay, so the trust is the administration of a person's estate, sometimes even before they die, outside of court supervision. So if you have a trust and someone is alive and they own property and they lose capacity, they get dementia, and you need to sell the house because mom has dementia, dad's no longer here, the successor trustee would take over and be able to sell the house under the trust. Mm-hmm. Same thing after death is an easier case. Successor trustee takes over to administer the trust without court supervision, and distributes the property to the beneficiaries, hopefully in an orderly fashion, but you don't have to petition the court. You don't have to, there's no filing fees. You do most likely need an attorney to assist with the administration, but typically the administration of a trust that's simple and uncomplicated might be $3,000 to $5,000 in attorney's fees. You can see the difference. Could be less if the successor trustee doesn't need as much help. But the beautiful part is, and you guys have done probates too, with a probate, you have to either get sales confirmed, you've got to make sure you comply with the probate code, and it takes a while to get through a sale unless you have a different kind of authority under the probate code. With a trust, the trustee can simply, after either before death or after death, retain the real estate agent, doesn't have to get court authority to sell, and sell the property, have a fiduciary duty to act in the best interest of the beneficiaries. So you can't undersell the property, but you can't buy it yourself. That's a a breach. But you can act much quicker and resolve everything much quicker. I've seen a trust resolved, believe it or not, in 4 months, resolved and distributed in 4 months. That's super quick.
Yeah.
And it can take longer, but it's still much faster than probate, and the fees are less. Trustee fees are less.
Okay.
And so you've answered the question, like, what is a trust? What are the various types of trusts? I know there's like revocable, irrevocable.
We'd have to have another Zoom meeting to go through all, but the main categories is the irrevocable trust and revocable trust. Revocable trusts are trusts that either married couple or a single person that can be amended or revoked as long as the person has capacity. They're not amendable or revocable if the person is alive but they lack capacity. And then after death, the trust becomes irrevocable, which means whoever takes over as a successor trustee can't change the distribution. I look at it as a contract. It's a contract that has to be followed. All of the terms have to be followed, even during death, by the successor trustee. And if a successor trustee thinks that they can't do it, then they shouldn't serve.
Okay. And how much should someone expect to pay to create a trust?
I would say probably a minimum of $2,500 to $2,800, a maximum, depending on how complex. And I still didn't ask the second part of the question. I'll answer it next. But on up, and it just depends on how sophisticated the trust is. Irrevocable trusts are trusts that are irrevocable from the day that they are signed. That means if you change your mind, I don't like them so much, because if you change your mind, you can't revoke it. You can't change the beneficiaries. You're stuck with it. Those are often asset protection trusts or Medi-Cal protection trust. So an elderly person may establish a trust, place their property, convey it to the trust so they can get Medi-Cal, and but they can't have any control over the property. And the main purpose of that is so whatever Medi-Cal usage is paid after or before death, that Medi-Cal can't come back against the property to get reimbursement, which is what you can do in probate. Medi-Cal always says that in probate, but it may not be the best thing for everybody, which is why you don't see it that much. Most trusts are revocable, and particularly for married couples, because you never know whether you're going to stay married.
So Medi-Cal comes to claim funds during probate? Is that what you're saying?
Mm-hmm. So in probate, you've got to give notice to the Department of Health Services and to the Franchise Tax Board. And then the Franchise Tax Board will look up that person's social security number and see, did that person file taxes? Did they miss any tax returns? And they can go back forever. And they'll file a claim that has to be paid out of probate. And then Medi-Cal, they'll go back and see what the usage is, and then they will file a claim for the usage. And I've had usage as small as $2,000 and as high as $300,000.
Wow. Wow.
In probates, and that has to be paid back. There's no way around it unless the estate doesn't have the money. The executor and the beneficiaries aren't on the hook for it. It's just whatever the estate assets are.
Right.
Yeah.
Okay. So if you have a will, but you don't have a living trust, do you still go through probate?
Yes. A will has to be probated.
Got it.
Yeah, absolutely.
Okay. And what are the top mistakes people make when they're creating a trust then?
One of the top mistakes is the same as the choosing the successor trustee, same as choosing the executor. It's not choosing the right person, the person who is right for that particular job. And that's a decision that's based upon your particular circumstance, your beneficiaries, and their dynamic. So you may have somebody who's super smart, but they're toxic. That's not a good person either. So, and it can be a hard choice. The other is, I see it all the time, and we've experienced it, is people fail to fund the trust. So funding the trust, you have this beautiful document, and it says where everything goes, but the trustee has no right to distribute and administer the assets unless they're in the trust. So we'll have a trust that says, mom's house goes to son, but she never conveyed the house to the trust, and the house is sitting out there still in her name as an individual. So if my trust, my property, I owned it, Robin Chow, a unmarried woman is her sole and separate property. When I established my trust, I signed a deed that conveyed the property from me as an individual to my revocable living trust.
Right.
If you don't do that, you miss that step, then after death, attorneys like me get to charge $5,000 to go fix it. And how you get it into the trust is what's called a pour over will. So if you have a complete estate plan, you have the trust, you have a pour over will, and anything that was missed, the will bring into the trust. But of course, not without a proceeding in probate court and an attorney making more money.
Right. I think you did one
That's
of those.
that's the biggest thing I see. Other thing that I see is people love to do their trust on LegalZoom, and they check conflicting terms. So if the terms conflict, if you say in one part of the trust that the distribution is to this person, and then you get to the other part and you say the distribution is to another person, you're going to end up in court because you're going to have two people thinking they're entitled to the same thing. So those are the biggest mistakes that I see.
So you get what you pay for?
You get what you pay for. Yeah. Yeah. But but there are some people, I have some clients who I do other work for, do real estate work for, and their feeling is, you know what? Why am I saving them money? They'll get it later and they'll just get less. But most people want to make sure that it's done right. And the purpose that you're doing it is because you love someone enough to make sure that they're going to get whatever you have left. And so if you're going to go that far, I think it's worth doing it right.
I agree.
Yeah.
So if you have a trust, do you need a will?
Yes. So you need the will. You need an entire estate plan. And because, like I said, it takes care of you. The point is to make your life and the people that you name as agents, to make everything in your life more smooth while you're living, and the distribution of your estate after you pass away go pretty smoothly and pretty quickly with fewer headaches than probate. So you need a will, because if, like I said, if you miss something, the thing that's missed most from trust are bank accounts, and property is not transferred to the trust. So with bank accounts, if you miss bank accounts and they're still in the decedent's name, that will, you can use that will to get them into the trust. It's a probate proceeding, but it's a short 3-month probate proceeding rather than a 1.5 or 2 years. And most attorneys charge a flat fee for it. Other thing that can be done with accounts is you can leave the trust as a beneficiary of the account. So a lot of people don't want to change all their bank accounts, spend their whole life having, opening bank accounts and establishing accounts and had them for 20 years and it's in their name and they don't want to open a new account, close accounts in the name of the trust. Don't have to do it. Just get a beneficiary designation for the accounts that already exist and name the trust as the beneficiary. So when you pass away, the successor trustee goes to the bank, takes the trust, takes the death certificate, and the money is then paid over to the trust. Very, very simple to do. And it's those steps that are missed the most.
Mm-hmm.
Okay.
Very good advice. Okay, that's all of the questions we have prepared, but we do have some questions here. So I'm just going to start. Hi, David.
Okay.
Hi, David Dahl. My wife
Hi,
and I,
David.
my wife and I already have a living trust, but our attorney has died. We are looking for someone to represent us. Any recommendations, Robin?
Me, no.
Right.
So we highly recommend Robin. Just so you know, we've been working with her for a few years now.
Yeah.
You would be in great hands with Robin.
Yeah, and then let me say this, because that was a little bit of a joke. Here's what I really do believe. There are a lot of estate planning attorneys out there, a lot of good ones, and there's some awful ones. But it really is a relationship that you have to develop with that person where you trust them. And so I always recommend that you interview a few people. It could be me, it could not be me, it could be whomever your friends recommend, that you get, you have someone recommend, or you get a few recommendations so people have some knowledge of the attorney, and then you interview a few, and then you determine who you want to work with. Because you do want to refresh the trust I would say you want to look at it every 3 years. You can look at it yourself, and if nothing's changed, great. But if you look at it and you go, I just really don't know, that's when you want to go in and have an attorney look at it. The hardest part, and I will say this, the hardest part is, so when I draft an estate plan, I know it. I know it like the back of my hand. And the person comes in and they need changes. I can do the changes before they come in, and we can do the signing the first time they come in. But when it's not my trust, I have to read the whole thing, right? And I've got to figure out, what happened. And I think what you really want to look for too is an attorney that's not going to charge you an hourly rate to review your entire trust, because it's going to take hours. That they're going to give you a little bit of a break, knowing that you're going to be a client going forward. So that's what I try to do, compromise on that, because, otherwise you're going to end up spending as much having an attorney review the whole thing as you did the first time. So that you want to look for that too. You just want to find out what's your rate for amendments. And if you charge a rate to review the document, can you do that for a flat fee, or can you waive it?
Got it.
Thank you.
Okay.
Okay, the next question from Heather Primus. Who brings a petition for probate? What if there is no will, no spouse, no children? Who is the beneficiary in that case?
Okay, so if there's no will, no spouse, no children, probate code again says who the beneficiaries are. So first it's spouse and children, no spouse, no children. It's parents. If the parents are still alive, no parents, then it's siblings. If the siblings are all still alive, if there are no siblings, then it skips down to the children of the siblings, which would be nieces and nephews, and it spreads out from there.
Okay.
And it can get, I have one probate now where there are 56 intestate heirs.
Ugh.
For like, I don't know, 150,000 net after the property sold. So yeah, if you don't want to do a trust, please just do a will. Yeah.
Okay. And then who would bring that petition in that case when there's no spouse, there's no children, and there's no will? Who would bring the petition for probate in that case?
So the priority is the same priority as who the heirs are. So if it's if the mom is still alive, then it would be the mom or the parents. If not, it would be a sibling. But remember, all the siblings would have equal priority. And so that's when you end up with fights, when one sibling says, well, I'm the oldest, I should be the one. And then the other one, I'm the smartest. And you could end up with competing petitions.
Got it. Okay. Heather, hopefully that answered your question. From Roxanne Rose, what is the process if you have your property in a trust and you sell it and buy a new property?
Okay, so if you have your property in a trust and you sell it, so you can sell it as trustee of your own trust. That part is easy. If you purchase a new property, it depends. So you can purchase a new property as the trustee of your trust. You can purchase it right directly into your trust, unless you're getting a loan and the lender won't let you. A lot of times lenders getting a loan to purchase a property, they want you to purchase it in your name as an individual, get the loan in your name as an individual, and then what you do after the close is you simply convey it to your trust.
Got it.
Yeah, seems kind of silly, but that's the case.
Okay. Okay, that's all the questions. Anyone else? You want to type a question into the chat or raise your hand? I think that's it.
I added Robin's contact information in the chat, and when we send a recording of the session, her information will be included in that as well.
I think Roxanne, you wanted to say something?
Oh, I was just wondering, is there like a one-pager that you have, Robin, with like the terms and like the flow chart of if you have a will and then a trust, sort of what comes after or before what? Just because there's so many terms and options, it feels like to consider.
Like a summary? I mean, here's what I have. I have a probate flow chart, and my trust summary is a different document than that. I don't have them together. But if you want me to share something with you, you're more than welcome to contact me, and I can email you that.
Great.
I can email you what I have. Okay.
Thank you.
Okay. You're welcome.
Any other questions before we go? No? Well, thank you so much, Robin. This was very informative. I'm going to be calling you next week because I have a living trust, but I don't have a will. I didn't know I needed to have a will.
Yeah, you know what? I call them, and let me say, I call it an estate plan whenever I reach out to the client, because everyone calls and says, I want a living trust. And I correct them. No, you want an estate plan.
Yeah.
Because you'll end up without that pour over will, you'll end up in probate. And invariably there's something that's left out. Or I think someone just said, what happens if I sell my house and I have a trust and I buy a new house? Well, you buy that new house and you buy it in your name as an individual and you forget to transfer it.
Right.
Problem.
Right.
Yeah. And we would just say to everyone, anyone who has a house, you must have a trust. We've done plenty of probates and they are a complete nightmare. And it sounds like COVID has made them even worse, but do yourself a favor, spend whatever it costs and get a trust.
Yeah, and I want to say one other thing too, because beyond the trust, I just want to give a short example. I have a conservatorship, and if we only had a power of attorney, we'd be the conservator would have been able to sell the property without the conservatorship. So because of COVID, we're in this conservatorship. I have to sell the property. The conservatee has dementia, need a lot of money desperately to pay for her care. And we got an offer. The conservator accepted an offer to sell a house. And I filed the petition to confirm sale in April, and the hearing is September next week. I just got a notice from the court that they're continuing the hearing, the confirmation hearing, until December because of social distancing. So this is for a conservatorship. So these are the kinds of things that are going on in the courthouse now that you just never know. It's COVID one day, it could be something else another time. It's just do everything you can to stay out of the Superior Court while you're alive and after. Best advice I can give you.
Yeah.
Love what I do, but it's not efficient.
Right. Well, thank you so much, Robin. This was great. This was very informative. So we appreciate you lending your expertise and for taking the time to join us today.
Thank you.
Thank you. And we just want to say thank you to everyone who joined. Thank you for logging on.
Thanks, everyone.
You will get an email with this recording, and we'll include Robin's information in that email, so it's easy for you to reach out to her. 2 new messages. Much appreciated. Thank you. And guys, if you have any suggestions for future sessions, we're doing this the second Thursday of every month. We're holding a Zoom call on different topics. So please send us your requests for topics and we'll be happy to put something together that, that you want to learn about. Okay. So everybody have a great weekend and stay safe. And thank you for joining.
Thanks, everyone.
Bye, everyone.
Bye. Bye. Thanks, Robin.
Bye. Thank you.